to do a no kids, no property divorce. For those of you that are not familiar with the Dallas Volunteer Attorney Program, or DVAP as we like to call it, we're a joint program with Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary mission is to match low-income Dallas residents with private attorneys that will do their case from start to finish pro bono. One of the most common types of cases that we get are divorce cases. And one of the easiest ways to get involved in doing pro bono is taking one of our no kids, no property divorce. So today we have Elaine Mosier, who is going to give us all the instructions we need on how to get that done. Elaine got her JD from Texas Tech University. She is actually a former managing attorney for DVAP and is now a sole practitioner focusing on family law and animal law. She is excellent in her field, widely respected, and without further ado, I will turn it over to Elaine.
Thank you so much, Kristen. Thank y'all so much for being here. As Kristen mentioned, probably 75 to 80% of the cases that come through the Dallas Volunteer Attorney Program are family cases. A simple no kids, no property divorce is absolutely a wonderful way for you to get your feet wet in the world of pro bono. And in fact, you're really not even getting your feet wet. You're just getting them a little damp. So they're very straightforward, and it's an easy way for you to help someone out. And let me just say one thing. Sometimes people feel hesitant about doing divorces because they think, oh, am I, breaking up a relationship? Am I making somebody's life worse? No, you are not. That relationship was busted up long before that person ever came to legal aid. They are coming to legal aid for help. I always tell people, think about being trapped with someone that you don't love anymore, you probably don't like anymore, and they have at least some level of control over your finances and what you can do until you are able to legally extricate yourself from that person. That's what a divorce does for people. It allows them to be legally extricated from someone who may be out running up credit card debt, running up other kinds of debt that potentially could land back on that spouse. So don't think of yourself as a person who's busting up a relationship. Think of yourself as a person who's freeing someone. That's what a divorce typically does, is it frees someone in the legal sense. So now that I've given my speech about why divorces are important and should be done, let's get on to the steps of doing that divorce. First, you want to meet with your client. Obviously, that doesn't have to be in person. It can be on the phone. It can be over Zoom. It could be FaceTime, whatever your preferred method is. You will find that even folks who are poor typically have access to a phone that has FaceTime or that they can Zoom with. So electronic methods are typically available to everybody. The first thing that you want to do is double check that either your potential client or their spouse has actually resided in the state of Texas for the 6 months prior to the filing of the suit, and that they have resided in the county where they are requesting to file suit for at least 90 days. I know that seems sort of stupid, but it's kind of shocking how often somebody will get to almost the end of a divorce and realize that their client nor spouse have lived in Texas for 6 months, nor did they live in the county for 90 days. And divorce is weird in that you can't accrue jurisdiction while the case is pending. So you can't say like, by the time the divorce is granted, they will have lived here for 6 months. Or by the time the divorce is granted, they will have resided in this county for 90 days. It has to be at the time of filing. That's 6 months and 90 days. So just double check that with your client. Hey, how long have you lived in Texas? How long have you lived in Dallas County or Coffin County or Tarrant County or whatever county the divorce is taking place in? Also, be sure and ask for not only your client's full legal name, but their spouse's, eventually the respondent's, full legal name. It can't be, Bobby Joe, because Bobby Joe is what he or she goes by. It needs to be, if their name is actually Roberta Josephine is whose divorce you're filing. It's not Bobby Joe's divorce. Or Robert Joseph. It's not Bobby Joe. Also, you need to have, and typically when a case comes to you from DVAP, they're awesome and they have made sure that all of these things are filled out properly. So really what you're just doing is kind of double checking. Hey, is your full legal name Josephine, Roberta Josephine or whatever? Is your spouse's full legal name, Thomas Henry Davis? Also, you want to make sure if you are representing the woman, and about 90% of the time the clients that come through DVAP are female. If you are representing the woman, you want to make sure that she did not have any children that were born during the marriage that are not her spouse's children. I always tell people that one of the wonderful and horrible things about DVAP cases is that because people are poor, pardon me, they don't have the ability to pursue divorces and other legal cases that resolve their children or their divorce matters without DVAP being involved in their lives. So often DVAP cases can be procedurally incredibly complex because you often have multiple children born of different fathers during a marriage. And in Texas, when you're married to somebody, you are presumed to be the father of all of their children, whether you are in fact the father of all of their children or not. So if you are speaking to your client and you say, do you have any children that were born during the period of your marriage? And she says, yes, but it's not my husband's. Put the brakes, because that's not a simple divorce anymore. There are some other permutations that need to be taken care of. And if you want to take care of those permutations for your client, like if you say, yeah, I'm willing to do something a little more complex, call DVAP, let them know. They are going to be more than happy to walk you through any kind of weird procedural issues that you need to deal with in that situation. Or I think somewhere on the paperwork that I gave y'all, it has my email and my phone number. And if it doesn't, I'm going to give it to you right now. My email is jemosher@aol.com. Do not snicker about my AOL address. And my cell number is 214-538-6323. If you ever have a question about a DVAP case, or frankly, if you have a question about a case in general, and if I can answer it, I will. Let me tell you, I am much more responsive to emails or texts than I am phone calls. And I apologize for that, but I just am. So if you email me and say, hey, I went to the DVAP CLE and here's what I have a question about. Please feel free to email me or text me your question. And if I don't know the answer, I can usually find it. Or I'll be honest with you and say, I am so sorry. I do not know what the answer to that question is, but here's somebody who might. Because I know enough people that usually I can figure out somebody that knows the answer if I don't. So I just wanted to go ahead and give y'all my email and my phone number so that y'all can just jot it down somewhere. Put it in your own phone if you're like me and you can't remember anybody's phone number or anybody's email. So after you've talked to your client and you've gotten it all squared away that it's your client and their spouse, no children were born during the marriage, or all the children that were born during the marriage are now over the age of 18 and graduated from high school. Oh, by the way, that's a biggie in Texas. Children are still children in Texas, or at least as far as divorces are concerned, until they are over 18 and graduated from high school. Now, the reason that's important is that a spouse can be obligated to pay support for their child until 18 and graduation from high school. So if you're talking to your client and they say, oh yeah, all of our kids are 18. Well, we have our one son that's still in high school and he's not going to graduate until he's 19. Again, pump the brakes, because that means you have a child of the marriage that needs to be dealt with, because you're going to have a kiddo who is not going to graduate from high school until age 19. Again, that's not incredibly complex, but you probably want to, after you've pumped the brakes, you want to give DVAP a call and get Kristen to walk you through what you need to do in that particular situation if it comes up. Because even though, the folks at DVAP are fabulous at screening these, every once in a while, somebody gets past them where they don't give all the information that you need. And that's why you're, sort of the second line of defense of asking these questions. Now, we're back on track though. We got no kids. We got nobody that's 18 and about to graduate from high school in another year. We're ready to move forward. Now it's time to ask them about property. If anyone, meaning either spouse, owns real property, a house or a piece of land, that's not a simple divorce. Again, call DVAP. And if you're willing to stick on the case, they'll help walk you through it. Or again, you're welcome to text me or email me, same thing, and I can help walk you through it. But it's a little more complex if you have to deal with a piece of real property, because it needs to be awarded, it needs to be done, there needs to be special magical language, because we're lawyers and we like everything to have special language so that nobody understands it but us, and that's how we get to keep our jobs. So if you've made it all the way through, you've gotten their name, you've gotten their information, you know that there are no kids, there's no real property, all we're going to have to divide up is the pots and the pans and the car she's driving and the car he's driving, you are ready to rock and roll. Want to make sure that you've got the last 3 digits of your client's social and the last 3 digits of their driver's license number, because our legislature has, in its wisdom, decided that we need to include those in pleadings. I disagree with that, but I'm not in the legislature. Be sure and ask your client if there are specific things that need to be divided. Cars are always a specific thing that needs to be divided. At the very least, it needs to say, wife is awarded the, 2010 Toyota Corolla. husband is awarded the vehicle that he's driving if she doesn't know what kind of car it is. It at least gives some security to your client that the vehicle that they're driving is not going to get grabbed up by their spouse at some point because they're without a car. And if you're married and you own a car, it's your spouse's car too. So that way their spouse doesn't decide to swing by where they're living and take the car one day. At least he or she can report it stolen because they were awarded that car in the divorce. To the extent possible, it's always best to award a car with like 2007 Toyota Corolla, and here's the VIN number. That makes it easier if anybody ever has to report it stolen because their spouse did come and pick it up. And as I said, we've got in Texas the 60-day waiting period, the 90-day residency restriction, 60 and 90, 60 for the 6 months for the state. Sorry, I said 60, 6 months residing in the state of Texas and 90 days in the county. Once you file for divorce, and by the way, we're all required to e-file now. And if you're not familiar with that, it can sometimes be a huge pain and sometimes it can be real, easy going. In the packet that you're going to get from DVAP, and I've included it in the packet for this CLE, there's an affidavit of inability to pay costs. Every case that you have through DVAP is, truthfully, they're going to qualify under the affidavit of inability to pay costs so that no court fees have to be paid for the filing of the divorce. I always find it super helpful if you put in bold at the bottom of the affidavit that the case was accepted through the Dallas Volunteer Attorney Program. You are much less likely to have the case plucked out by the district clerk for purposes of arguing, arguing the validity of the affidavit of inability, because the Dallas County Clerk especially has in the last few years gotten on this kick of protesting almost every affidavit of inability that is filed in Dallas County. And so that means that an attorney for the county has to come in and they make the argument that your client can pay the fees. If they see that you are working through DVAP, they know that that person's already been screened. So it makes it a lot easier to avoid having to show up, even on Zoom, show up for a hearing where somebody's contesting the affidavit of inability. So I've provided you a sample petition for divorce. Typically, it's just the parties' names, the last 3 digits of the petitioner's driver's license and social security number, and the dates of marriage and the date of divorce. I have had more people who do not know the date of their marriage than you would believe in the course of my career. It just cracks me up that people are like, well, seems like it was about 10 years ago. So sometimes you kind of have to draw that out of them where you say like, well, do you remember where you were? What job did you have when you got married to this person? Where did y'all get married? As a way to try and trigger their memory for at least what year it was. I will tell you that I have filed divorces before that say, date of marriage, spring 1998. You don't want to do that, but if you have to do it, you have to do it. Same for date of separation. Sometimes that can get a little loosey-goosey, but to the extent that you can draw it out of them and get an actual date, that is super helpful, especially in the awarding of property. I know that for most of these folks that you're going to see, there's not going to be significant property, but you at least want to award it in such a way that you say, as of this date, she keeps everything she had in her possession, he keeps everything he had in his possession. After you filed, provide your client a file stamp copy of the original petition for divorce. In a simple divorce, the hope is that the spouse will sign a waiver of service. Now, what I always tell my clients is, if you can physically meet with your spouse, hand him or her the copy of the original petition for divorce, hand him or her the waiver for them to read it, then take them to a notary to get the waiver notarized. You are much more likely to get the waiver back. You know, you can have lovely, wonderful people who have every intention of signing that waiver of service and getting it notarized, and it just doesn't happen. So what I typically try and do is calendar about 20 to 25 days after I've given the waiver to my client. And I then follow up with my client and say, hey, have you given the waiver to your waiver in the original petition to your spouse? Are they going to sign it? Do you happen to already have it? And you just, you haven't forwarded it to me. You just got to figure out what's going on, because if they are not going to sign the waiver, then you need to get them served. And again, because you have that affidavit of inability on file, you can get the sheriff or the constable, to serve the respondent in your divorce case for free. Nobody has to pay, but you have to go to the courthouse. Actually, don't go. You don't go. You e-file another copy of the file stamped original petition for divorce and request that the clerks issue citation to the respondent, and then forward that citation and petition to the appropriate precinct. You will have to look up the precinct and tell the clerks what precinct it is. So all you do is, if you go to the Dallas County website, it has all of the JP precincts on it, and you enter your client's phone number and find out what precinct they're in. Typically what I do is call the precinct and just confirm that they serve papers at this address, just to make sure that there's not some overlap or weird thing where it shows that that's the precinct, but it's really not. When you file for divorce, and I apologize, I didn't say this at the beginning. Once you file your original petition for divorce, there's a 60-day waiting period from the time that you can file, from the time the divorce is filed, until you can actually submit the final decree of divorce, and the divorce can be granted. So like really day 61 is the first day that you could pursue the divorce decree. Marissa, did you need to add, Marcella, pardon me, did you need to add something?
No, sorry.
No, that's okay. I just wanted to make sure that I hadn't said something weird and that you were about to go, well, no, that's not really. Because, sometimes I will say something weird and somebody needs to say, well, that's not really what needs to happen. So from the time of filing until the time of finalization, it's actually 61 days. Now, if for some reason you have a case where you have like a super on top of it client, and they say, hey, I can take the waiver to my spouse. And if you get the final order done, I can take that to my spouse too, and then he can sign everything at one time. Awesome. You want to do that if you can, because the best way to avoid any future issues with any divorce that you file or finalize is either to take it to trial and enter an order based on what the court has rendered, or you get agreements about everything, meaning they sign off on a waiver that says, no, don't have a sheriff serve me. I know that there's a divorce pending and I'm happy to sign. And get them to sign off on the final decree of divorce. Because then they can't say, I didn't understand what that waiver meant. I was totally confused by that. So I didn't understand that that meant that I should tell the court that I'm contesting her keeping. I always like to tell people my very first trial that I had was over a Walmart rug and a ceiling fan. It was a pro bono case because before I worked for DVAP, I'd volunteered with them. And the husband wanted back this Walmart area rug and a ceiling fan, also purchased from Walmart. I was like, I really think that's not even $200 worth of stuff, but okay. And we had a trial over it. And my client got the Walmart rug and the ceiling fan. Yes, thank you. I'm a very good attorney. So if you want to just make sure that your divorce is bulletproof, you want the respondent to sign the final decree of divorce. And you have a sample of that in your packet of stuff that you're getting from DVAP. Because honestly, the biggest issue with which you're going to be faced in these simple divorce cases is getting them to sign the waiver. Not that they don't want to sign the waiver. It's one of those, like I said earlier, we all have great intentions of doing things and then we just don't do it. So you need to stay on your client so that your client can stay on their spouse about getting the waiver signed. Once you have that, you then forward the final order and let them sign that. I have found that sending it in DocuSign or Adobe Sign or Hello Sign, one of the signing, not the waiver, because a waiver has to be notarized, but the final decree, it's easy to get everybody to sign it through any of those signature programs, because then they can just touch on their phone, yes, I want to sign. And then boom, their signature's on there. And then you present it to the court. So nowadays, because of the pandemic, I'm naming myself as old, because back in the day, you had to physically go to court for everything. You had to physically go to court to file. You had to physically go to court for the divorce prove up. If there was a contest of the affidavit of inability, you had to have a physical court hearing. Nowadays, most of the things that I've just described can be done via Zoom. Or some courts even allow, for completely agreed divorces, a divorce to be granted by submission. And I've included in your packet from DVAP an affidavit for prove up in case you're in a court that allows submission on agreed divorces. Now, just so you know, what that means is if you have your original petition filed, you have your waiver that has been signed and properly notarized. And by the way, you will see that there are some blanks in the waivers. That's on purpose. The respondent needs to fill out their address. They need to fill that out so it's clear that that is their proper address. So if you've got your petition filed, you've gotten your waiver signed, and you've gotten the final decree of divorce signed, then there are a couple courts, like the 330th, I think still does it. I think the 255 might, under the new judge, allow divorces by submission. And that's where your client signs off and has notarized an affidavit that includes all of the language required for a divorce prove up in Texas. And a divorce prove up in Texas is merely a few questions which you lead your client through. It's, my name is X. My spouse's name is Y. I have lived, or my spouse has lived, in the state of Texas and the county of Dallas for the 6 months and 90 days preceding the filing of this suit. We were married on or about X date. We were separated on or about X date. Our marriage has become insupportable due to discord or conflict of personalities that destroys the legitimate ends of the marriage relationship. There is no possibility of reconciliation. There were no children born or adopted of our marriage who are currently under the age of 18, and no children are expected at this time. My spouse and I have entered into agreements regarding the division of our property. We believe that these agreements are just and fair to one another. We believe this is the appropriate way to divide our property. I'm keeping everything in my possession. He's keeping everything in his possession. I'm being awarded my car. He's being awarded his car. I'm asking the court to enter our decree of divorce today, approve all agreements, and grant our final decree of divorce. That's what you do if you're on Zoom. That's what you do if you're in person. You ask your client those questions. And what I tell my clients all the time on divorce prove ups is, I'm going to ask you the questions in such a way that you should be able to answer all those questions, yes or no. You want to say yes to everything except, can the two of you get back together? That answer should be no. Otherwise, why are you trying to get a divorce? So you don't have to appear in court for the filing. You may not even have to appear in court for the prove up, but if you do, I have the prove up affidavit in there, and you can use that for an oral prove up as well. You just take those affidavit questions and turn them into questions for your client. Now, if you have to have a respondent served, if they're not willing to sign the waiver, you're going to be using, as I said, typically in a DVAP case, you're going to be using the constable for service. What I always do is, when I have e-filed my petition and requested the clerk to issue service, and forward it to the appropriate constable's precinct, I will also follow up with the constable's office and make sure that they got it. Like, typically I'll do like 5 or 6 days after I have filed electronically the file stamped original petition of my request. You typically should do a request letter. I find that the clerks are more responsive to that than just sending them a note in the comments. If you do a request letter that just says, dear district clerk, attached, please find a file stamp copy of the original petition for divorce. Here's the cause number. Please issue citation associated with this cause number to respondent, whose name is, John Brown. And sorry, cough drop. Forward to precinct bloody, bloody, bloody. You know, precinct 1 located at so-and-so address. Once you've done that, just calendar about 5 to 6 days, maybe 10 days, to check on whether or not the precinct has actually received it. Because if the precinct says they've not received it, you might then start having to kind of chase it down through the clerk's office, see if maybe it accidentally got sent to the wrong precinct, see if for some reason it just hasn't been done yet, find out why. But all of those things can be done during that 60-day waiting period. Once you get the spouse served, the return has to be on file for a minimum of 10 days prior to the divorce being finalized. Not so with a waiver. You can file the waiver at the same time that you file the final decree of divorce, so that the court knows they can sign off on it. Like, if they've signed the waiver and they've signed the final decree of divorce, and you're going to do your divorce by submission, if the court allows it, you can file the waiver, the final decree of divorce, the Austin form, which is always in your packet, and the affidavit for submission. You can actually file all that at the same time, but all of them have to be filed as separate lead documents. It can't be filed as one long document. I know that's dumb, but the clerks, I guess, don't have the ability to separate out documents. So things need to be filed as lead documents, not as attachments. So if you've served the spouse, the respondent, then what you need to do is make sure that the respondent has actually been served. And you need to find that out, because sometimes the constables will return a citation unserved, but they don't note that it's unserved. So you look on Odyssey and you see, oh, citation returned. Yay, my person's been served. No, they actually weren't. So what you need to do is call the constable's office and say, hey, you returned service on blah, blah, blah. I just wanted to make sure the date and time that you actually got him served. Then you'll find out. If the constable says, I went out to the house 3 or 4 times, no one answered, but somebody told me that he actually lives there, but just wasn't there then you can ask for substitute service. That is something to go to Kristen about, or me about, or, just back to DVAP. They can help you with that. And I know I'm making this all sound complicated, but it's really not. It's truly the hardest part of the whole thing is getting that waiver or getting the respondent served. And once you've done that, it's total gravy. Because your final decree of divorce is going to be pretty simple and straightforward. There's a sample in your packet that you're getting from DVAP. It's just a very straightforward document that says, this is who the 2 married folks are. This is the basis of the divorce. And for DVAP, typically the basis of your divorce is our no fault ground in Texas, what we call the insupportability ground. then you, as I said, you divide up the pots and the pans, meaning she keeps her stuff, he keeps his stuff. She gets her car, he gets his car. He keeps all his debt, she keeps all her debt. Place for the judge to sign, and you're done. And in 60 days, you have helped release someone from the chains of their marriage. I'm going to check and see if I've missed anything in my little, oh, and by the way, the kind of checklisty thing that I'm looking at is also in your packet. Oh, I forgot to include one one thing that's a Zoom issue. Typically, you don't get emailed a copy of the signed final decree. You can tell your client to go to the records division the day that the divorce decree is signed, and they will get a free certified copy of the final decree of divorce. Anytime after that, they have to pay $1 a page. The clerks will not email you a copy of the final decree of divorce. So if you want a copy just for your file, you can request it from the records division, and you can send them a copy of the affidavit of inability to pay costs. They won't send you a certified, obviously. They'll only send you a plain copy. But if you're like me and you like to have a copy of the final decree of divorce just in your records so you know for sure it was done, you can email the records clerk, and I've put their email address in that little checklist that I created, because that will allow you to have a copy for yourself. And if your client doesn't need a certified copy, you can email them a plain copy. I strongly recommend that you have your client go to the courthouse the day of the prove up and get a certified copy. There will be some reason, unknown to you and unknown to your client, when 8 years, 10 years after their divorce, they need to have a certified copy of that divorce decree. I always tell my clients, you can go make as many copies of that divorce decree as you need. If you need to give one to your job so they know you're divorced now, if you need to give one to your to the people at the car place where you're buying the car, excuse me, because they need to make sure that you're divorced now. All those things, they can just make copies of that certified copy that they go pick up that very first day or the day that the divorce is finalized. But tell them to hang on to that certified copy, keep it in a safe place, because like I said, there'll be some reason 10 years down the road that they'll need a certified copy of their divorce decree. And that saves them the, trip down to the courthouse later, paying, 15 or 20 bucks for the copy, all that sort of thing. So it looks like we've got a little bit, about 10 minutes left or a little bit more. If you have any questions for me, I think you can type them in and I'll answer them.
So it looks like there aren't any questions in the
All
chat.
right.
But for everyone who attended this afternoon, thank you for attending. The CLE course number is in the chat, but I'll also say it here. It's 174 174-185-239. Again, that is 174-185-239. I included the link earlier in the chat where you could download the different copies that were discussed during Elaine's presentation. But I'll also be sending that link out via email for everyone to download. So that will be coming out within the next day. So look out for your emails, and that'll be from Zoom. Let's see, there's one more. Oh, no, yes, I've answered that question. But again, Elaine, thank you for presenting.
Thank you all. And like I said, everybody feel free to shoot me an email, shoot me a text if there's something that you were like, I'm not sure what she said about that. Feel free. I'm happy to answer.
Thanks, Elaine. And again, I included her email and her phone number, as well as the link of the packet in the chat. But if we don't have any questions, again, everyone, thank you for attending. And we hope you have a good rest of your afternoon. Thanks,
Thank
Elaine.
you so much.